Industrial Employment Act 1946, which is also called as Standing Order Act. So, hello, good morning, everyone. My name is Sujit Sankhe, a second year student of SAS Institute of Management Studies. Today, I'm going to present a PPT on a subject of labor laws and implications on industrial relationship, which is taught by Professor Santosh Sankhe sir. So first of all, we'll see the objective, scope, and applicability of the Act, then the definitions, procedure, certification, modification, appeal for the Standing Order Act, then the payment of the subsistence allowances, penalties, and act of the misconducts which comes under this Act. So first of all, we'll see the objective, why we have done this, why we have made this act. So objective is to minimize the industrial conflict, to foster harmonious relationship between employer and employees, then to require workers to define the conditions of the workers. So basically there was a no uniformity in the conditions of the services of the workers until this act was bought. Then this act was bought. The frequent causes of friction between management and workers in the industrial undertaking in India were mainly due to absenteeism, absence of clear cut employment conditions known to the worker. This is why the leader or labor investigation committee 1944 and 1946 observed an industrial workers has the rights to know the terms and conditions which he has expected to follow. And opinion is a favor of the separate central law, making it obligatory on the part of employer in the country to frame and enforce and appeal government approval of the government defining the law of environment employment conditions. So this comes under this act. So this is the main objective, to require workers to define the conditions of workers so that they will follow it properly. Then the scope and the applicability, who this act, who will be comes under this act. So here is this act apply. This act apply to the whole India, including Jammu and Kashmir. It implies to every industrial establishment wherein 100 or more workmen are employed or were employed on any other working day of preceding 12 months. So what it says, it implemented or applied to whole India, including Jammu and Kashmir, and it is also applied to the industrial establishment where 100 or more workers are working, and it may that it is on any working day of preceding 12 months. So this act not applicable to certain industrial establishment, like to which the provision of chapter 7, the Bombay Industrial Relation Act 1946, 1946, or Madhya Pradesh Industrial Employment 1961 are applicable. So to for this act, this act is not applicable. Now we'll see some definitions. So here are some concepts like certifying officer. Certifying officer, it means the labor commissioner who is appointed by the appropriate government for the purpose of certifying the standards standing order. So this person will certify the standing order. So this is for the certifying officer. Then the appellate authority, it refers to an authority which is appointed by the government for the purpose of seeing to an appeal provided by the employer or any of the workmen. If the employer or from the any other workman the appeal is given or appeal is raised, then that appellate authority will see that appeal and they will do the some required procedures to modify the act. Then we have standing order, the rules pertaining to working of establishment to be submitted by employer. These are the kind of rules which the employer wants that employee should follow. So this comes under the standing order. Then we have procedure, certification, modification, and appeal within a 6 months from the date. So standing order should be applicable within a 6 months from the date on which this act is applicable to an industrial establishment. The employer required to submit 5 copies of draft standing orders. So this should be submitted. Employer should draft the 5 copies of standing orders to the various persons. Then the certifying officer To the certified officer, we have to submit that 5 copies to the submitted certifying officer. Certified officer shall forward a copy thereof to the trade union if any workman has objection on it, and must, if any workman or the trade union member have any obligations or any problem objections with the draft, then that should be submitted within the 15 days to the uh, certifying officer. The certified officer will certify that draft within the 10 days after giving the green signal from the trade union and other workmen. Then we have appeal. Who can appeal and what can appeal? Any employer or workman trade union aggrieved by the order of the certifying officer may within 30 days appeal to the appellate authority. They should give appeal to the authority within the 30 days. So the appellate authority shall within 7 days of its order send copies to the certified officer. They will do the whatever the workman or the employer wants changes, they appeal. They will give the uh, another draft copy of this standard act orders, standing orders. Then this will submitted to the certified officers to the employer and the trade union as certified by it and authenticated in the prescribed manner. The appellate authority has no power to set asides of the orders in the certifying officers. Then when the standing orders to be modified, so under section 10 subsection a, standing orders finally certified under this act shall be modified until the expire of 6 months from the date on which the standard order came into the operations. Then who can do the modification? So the employee can do the modification and employer, these both persons can do the modification or apply for the modification. Then we have the payment of subsistence allowances. So when any person who found in a problem, and who is the and who has the any employee comes under this act and the inquiry is going on, so at the rate of 50% of the wages which the workman was entitled to immediately preceding the date of such suspension for the first 90 days of suspension. So if any person or employee is suspended from his services for any reasons, and he must be innocent or the fault which is not proved, so till the 90 days we have to pay. Employer should pay 50% of the wages because of his completing basic needs. If the procedure, the whatever the disciplinary action against the person is going after the 90 days, then we have to, employer should have to pay 70% of the wages for that remaining period of the suspension. If any dispute arises regarding the substance allowances payable to the workmen, it may be referred to the labor court constituted under Industrial Dispute Act 1947. Then we have to see the penalties and the act of misconducts. An employer who failed to submit draft so shall be punishable with the fine which may extend to 500 rupees, 5,000 rupees, and in case of a continue offense is further then the 2,000 rupee 200 rupees for the every day. An employer who does any act in contravention of standing order which certified under this act will punishable with the fine which may extend to 100 rupees in case counting continuously the offense then may increase to 25 rupees per day or every day after the first uh, contravention has done. Then we have the some act of misconduct. So we can say I have choose some act of misconduct. There are many, but we are going to see some act of misconducts like going on a legal strike, willfully slowing down in performance of the work, taking or giving the bribes in the organization, theft, fraud, or dishonesty in connection with the employer's business or the property. Then it gives the punishment to it comes under this act. Habitual absenteeism without leave or absence without leave for more than 10 consecutive days. Then the drunkenness, rioters, orderly or indecent behavior on the premises of the establishment. This kind of misconducts are incorporated in this act. So this is all about the Standing Order Act. Thank you so much.